the candidates a couple of questions that are similar so that, you know, people can do some comparisons.
Okay.
And sorry if this ends up getting a little discombobulated and running all over the place, but I think the first thing that really, you know, kind of struck me is, although it's not the most crowded field ever, I mean, for this race, I mean, to have 5 candidates is quite a lot, particularly in a race where I think people don't necessarily know, not that they don't care, but they don't necessarily know what it is they should be looking for in a judge. So I guess my first question is, how do you kind of distinguish yourself from the pack, if that makes sense?
Sure. No, I understand. First of all, you're right, because unlike a legislative race, particularly a local race like the supervisors' races, where you're used to seeing the supervisors in the paper a lot, they're on TV, they have a lot of meetings, there's a lot of events. With judges, unless you go to court, you wouldn't know who the judges are, because they're really not public officials in the sense of a legislator. They're officials because they're working in the court system and they're elected usually. But they're not in the public eye very often, which leads to the next question, which is, why would there be a crowded field for a judge's race? And the answer to that is, there are only 2 ways that a person can become a judge. You either are appointed by the governor, and if that happens, the governor appoints you to where there is an open seat and they need a judge to be. So that's why you see a lot of judges in counties that they may not necessarily be from, or people are familiar with them because they might be appointed somewhere else because that's where the governor needs them. The other reason is because if you decide to run for an open seat, then you're going to get a lot more competition, because it's really not very common at all for somebody to challenge an incumbent judge. It's very rare for a few reasons. First, once somebody becomes a judge, unless they don't like it, they usually become very comfortable. They are qualified, and barring some sort of a scandal, they're probably going to be doing a good job as a judge, and they're going to last as a judge for the end of their term and be reelected pretty easily. So what happened here with Judge Dowling retiring is it opened the seat so that people didn't have to run against an incumbent, and as a result of that, we got 5 people in this race. And all 5 of us are very different. I think, although we're all very qualified, which is great, and that's good for everyone, our personalities, our backgrounds are very different. We have 1 federal prosecutor, although this is a county election, which means that this is a state court seat. He's a federal prosecutor, which means he practices in federal court as opposed to state court. So we have 1 candidate who has a strong federal background and a strong prosecutorial background. Then we have another prosecutor who is from the district attorney's office. So she has more of a state court experience, like I do. We are the 2, by far, I think, the most experienced trial lawyers in state court. Not that being a federal prosecutor means that you're not a good trial lawyer. It's just very different in federal court than it is in state court. So we have 2 prosecutors. One's a federal court prosecutor. One's a state court prosecutor. Then we have one of my other opponents is a research attorney, and so she's not a litigator at all. She admittedly doesn't try cases. She doesn't go to hearings. She stays behind the scenes and does the research. So that makes her very different. Mm-hmm. And then the last one, he's older. He does have, from what I understand, a good litigation pedigree, and he's been in court all over the place. And so that's the 4th one. Where I come from is very different than all of those, because I've never been a prosecutor. I've never worked for the government. Three of my opponents have. You know, both prosecutors and the research attorney are all, one federal employee and 2 state employees. I have been in private practice my entire career. I've had my own firm now for over 10 years. So that makes me very different than everyone else, because unlike them, where they go to work and do their job and get their paycheck, I have to go out and find the work. If I don't have work to do, then I don't get paid, and my staff doesn't get paid, and the lawyers that work for me don't get paid, and the rent doesn't get paid, and my mortgage doesn't get paid. And so I I come from a much different background than the other four because I've been a business owner and responsible for finding the work, doing the work, and like any other business, if you don't do good work, you will not stay in business. So that's one of the reasons I'm very confident in my capabilities, not only because I've been doing it so long and I've been to court so many times. I've tried dozens of cases, I've done hundreds of motions, taken hundreds of depositions, been through hundreds of settlement conferences and mediations. So I'm very comfortable and I think very well trained from that point of view. But also because of the fact that I've been in private practice and I own my own firm, it gives me a whole different perspective on the legal system than somebody who works for the government and goes to work every day. So I think that's one of the reasons that I'm different than my opponents. Also, as you know, I have a limited criminal background because I have done some criminal defense work, and in this county, in fact, I've been in front of Judge Dowling in civil cases, and he sat in on criminal hearings too. But I've been in front of the other judges as well. But I also have a larger civil experience in this county than I think anybody else. I don't think anybody other than maybe Jeff Ingram, although I'm not sure, has actually ever argued any law in motion or done any civil work in this county other than me. By definition, 2 prosecutors and a research attorney. So that makes me very different because I actually have been to the clerk's office and I have to file my own documents, and I have to work with the staff, and I've argued and seen you there many times, which leads into the other reason I think I'm very different than the other candidates, and that is because throughout my career I've never been afraid to take on difficult cases, complicated cases, highly publicized cases, controversial cases. And one of the things that's important about being a judge is that you have to be composed. You have to be fair. You have to be able to look at everything, and you can't get swallowed up by your emotions. And because I've had a lot of experience dealing with very controversial cases, I'm used to that. I'm able to take the criticism for handling a case that other people may not have, for advocating on behalf of a client that people might disagree with their views. One of the big ones is, of course, the medical marijuana cultivation issue. That's such a big deal in this county. Mm-hmm. And with my involvement in the ASA case, we saw, and as you know, you were there for a lot of it, that people's emotions would run very hot on both sides of the issue. And it was very important for me to make sure that when I was in front of Judge Dowling, that I would not be caught up in the emotion of the issue that is the basis for the case, but rather to focus on the legal issues, to make sure that I could communicate to the judge what it is that we were trying to have him decide and why and what that precedent was. And of course I had to do the research myself, which I did, do the writing myself, which I did, and then present the argument and try to make it in such a way that it was clear and understandable so that we could get a good ruling. I've always been the leader of my firm, which means that I've done a lot of research and a lot of writing. I know that a lot of lawyers rely on other people to do that work for them, and throughout my career, I've been the one who has been responsible for that research and writing. So I think that plays very well into my strengths in becoming a judge. When you put all of that together, I think you find that not only am I taller than everybody else, but with my experience, I think it's a lot more well-rounded, a lot broader, in the sense that I've had to handle a lot of big cases and controversial cases and done very well with them.
You brought up, and I actually was going to hold this question, but since you brought it up, I think I'll go ahead and jump to this. The work you've done on behalf of ASA for the medical marijuana cultivation ordinance. I obviously your perspective on medical marijuana and maybe I'm putting words into your marijuana in general is going to be different than sort of the standard by which cases get criminally prosecuted in this county. I mean, as a judge, how would you kind of reconcile that, or would?
Right. Well, first of all, what my personal views are become irrelevant as a judge, and the reason for that is because a judge has to follow the law. There's no choice. You may not like it, but it doesn't mean that you can deviate from the law. You cannot. You have to be fair. You have to follow the law, and I will do that. And part of the reason I think I'll be very good at that is because, like you mentioned, if I'm advocating for ASA and what they are trying to accomplish in their case, it doesn't mean that I agree with them. It doesn't mean that I am an activist, which I certainly am not. I'm a lawyer trying to advocate their legal position. And so I think that translates well into being a judge, because I've particularly in the medical marijuana issue, I've seen both sides of it. I've heard all of the arguments, and I know what the law is, and so I know how to apply that law. One of the issues that's really important always in every case, particularly a criminal case, like you mentioned, is certain areas a judge has no discretion. Sentencing, for example, may have strict guidelines where you have no choice as a judge. But there are other instances where a judge has discretion, and it might be a sentencing issue. One of the things a judge is not allowed to do, or at least a judicial candidate though, is talk about anything that might be a litigation in front of them in court, or take a position that would lock them into a position if they were elected to the bench. So what that means is you have to look at every case on a case-by-case basis. You don't know. I can't say, for example, I advocated for ASA, therefore I'm a proponent of medical marijuana, and as a result of that, I'm going to make rulings in a certain way. I can't do that. I wouldn't do that. It's improper, and I wouldn't do it. I will tell you, though, that when it comes to, as we use an example of medical marijuana, if there was a sentencing issue, I would be able to understand the impacts that medical marijuana may have on a particular patient, and whether or not incarceration is the right sentence, or whether or not there might be drug-related issues, or there might be other circumstances that could affect my discretion in sentencing. Then I would be able to look at all of those issues very carefully, put it together for that particular person, how it would affect them, but also, equally if not more important, is how that affects the public safety, how it would affect any potential victims if it was a crime, and when you look at all of that in totality, then you can make the decision, if you're allowed to have discretion, for example, on, is it better for that person to go to treatment? Is it better for that person to be incarcerated? I don't know. But I have seen a lot in the medical marijuana field because of my work with ASA and in other cases, to know that every qualified patient is different, and every case is different, and every circumstance is different. And one thing that's really important to me is that people cannot be prejudged, particularly medical cannabis patients. If they feel like they are not going to get a fair shake because they're going into court, it could be a civil case too. I mean, I think you covered a couple cases we did last year.
I think there was somebody who had.
Right, neighbors.
Yeah,
remember
they were complaining about the smell was causing her.
Right, and in that case, people they didn't want to be there because they thought that if they took their grievance to court because of the stigma of whatever the case was about, they might not be treated fairly. That's a horrible position for anyone to be in, because nobody wants to go to court. Nobody is, or hardly anybody, is comfortable in court. It's a scary place to be. And particularly if you think that you're being prejudged because your case is about something controversial like medical marijuana. I know, because of my background and experience, that I don't prejudge anyone. People need to be judged on their own merits, not because of a stigma that might be placed upon them because of what type of medicine that they use or how they try to meet their medical needs. So I think, I can't speak for the other candidates, but for me, one of the things that's really important is that if you're going to come into my courtroom, it doesn't matter who you are, what you look like, if you come in, you're going to have your case heard fairly, and you are going to be treated exactly the same as if you come from a rural background and maybe a medical cannabis patient, or if you come from a corporate background and your life experience is different. So I think I can handle those issues pretty well.
Okay, so I'm going to totally switch gears again. Sorry.
Okay, that's fine.
Keep you bouncing around. I brought this up in the League of Women Voters Forum, and it's such a complex issue. I kind of want to revisit it, and it's the whole revolving door issue because
Right.
I think that there's a lot of confusion in many people's minds about how it happens that a defendant can be in and out both of jail and in court on multiple cases, and in a lot of instances they don't they don't get a high bail, and I think too that people don't really understand how the bail schedule works.
Right.
So I was hoping you could kind of speak to that.
Sure. Bail has one purpose, and that is to make sure that people come to their court dates. It's not like the sentencing at the end of a case where you're trying to decide how to have somebody rehabilitated or to be punished for their crime. Mm-hmm. Bail is intended to make sure that people show up so that they can be present at their hearings or at their trials. Because remember, the judicial system and court is nothing more than a forum for disputes to be resolved. That's it. So to think that somebody has to stay in jail before they've been convicted would mean that they have already been convicted. So bail is intended to make sure that people go to court so that they can participate in the system, and they're not going to run away. So the trouble is...
That's, obviously, I'm amazed at the number of FTAs I see on any given.
Right. FTA means failure to appear.
Yeah.
And you're right. And what happens then if somebody is out on bail or on bond and they fail to appear at a hearing because that's what they did, they're either out on their own recognizance, they call that OR, or they've posted their bond because the judge that set the bail was confident that that amount was enough to make the person show up, and then the person doesn't show up, and FTAs, they're going to first of all have their bond revoked. And that means an arrest warrant's going to be issued. Why? Because they've blown it, and now they're not trustworthy to show up to the rest of the case, and they can be arrested and they can be incarcerated. And when they are in custody, their bail either is going to go up significantly unless they had a great excuse. And sometimes that happens. I mean, if you're in a car accident and you're in the emergency room having surgery and you miss your court date, judges understand that. There are sometimes good reasons, but just not to go to court is a bad reason, and as a result of that, you're either going to have your bail significantly increased, or you might not be allowed to have bail at all. So you're right, people need to understand that they may not be happy that they were arrested. They may not think that they are being treated fairly for whatever reason, but if you have to go to court, you need to be there. And so the revolving door idea is, well, how do we set bail high enough to make sure people, are going to come, but not so high that they can't afford it, and we fill all of the jails with people just waiting for their cases who may not even be guilty. And do we really want to fill the jails full of people that have not been convicted yet because they can't afford bail? That's a tough question, which is why judges sometimes struggle with that. Although the bail schedule is not set by the judge, typically they're in place, and unless somebody brings a bail review hearing, for example, because they think the bail was set too high, and the judge lowers the bail, which happens, then the judges really don't have a lot of discretion when it comes to setting bail. The problem is, if there's repeat offenders, we need to understand why, and we need to stop that, particularly because if public safety is the number one goal and fairness and equity is applied, and you have to look at what a person who has been charged with the crime has done and what its effect is on society, we also need to balance that with what is the right remedy. And if you put somebody in jail that doesn't need to be there, that might not be the right remedy. But if it's a revolving door and somebody just keeps going out and committing these crimes over and over and over, and he's getting convicted over and over and over, then obviously there's a problem. And it's a very difficult balance, and again, it's impossible to tell other than on a case-by-case basis what to do, because everybody's different, the circumstances are different. But you're right, I don't have a lot of tolerance for people who fail to appear to their hearings. Along that line, though, I actually don't have much tolerance either for lawyers that fail to appear. And you would be surprised how many lawyers miss court dates. It is shocking to me that lawyers ever miss court dates. That's their job. You know, I mean, can you imagine working at a restaurant and then, you know, everybody comes to try to get something to eat and there's no food? It slows everything down. You know, that's one of, and yeah, I think you've heard me say it too, one of my criticisms of the court system is that it is impacted. It is hard to move cases along, and judges, part of their responsibility, and I think it's an important responsibility, is to make sure that cases move along. You need to get resolution, and there are lots of ways to do that. In a civil case, I'm a huge proponent of alternative dispute resolution, ADR, which is mediation, arbitration, ways for parties to get in front of a neutral expert, typically a retired judge or lawyer, to have their, you know, not their day in court, but to have their date with a neutral judicial officer, and those types of disputes are often settled much more efficiently, much faster, a lot cheaper by using alternative dispute resolution. And on the criminal side, there's other mechanisms too. There's the alternative courts, which you're familiar with, which are very good, and there's also plea bargaining. And you know, it's one of the things people don't like to talk about too much. But even in California Lawyer this year, or this last month, the cover of the magazine was about plea bargaining and why it's so important and how it works. And like settlement in a civil case, plea bargaining in a criminal case is a way to have, first of all, resolution. Typically, it's going to be relatively fair because it has to be agreed upon by both sides, right? The prosecutor and the criminal defense attorneys have to agree. Then it needs to be ratified by the judge. So plea bargains are not necessarily a bad thing, particularly because a lot of people who can't afford their lawyers don't necessarily have a chance to take their case all the way to fruition because they can't afford it. And so a lot of times people are encouraged to or would like to enter a plea because the downside liability exposure that they're facing if they went all the way to trial and they were not prepared is significantly less than if they negotiate a deal, particularly early on. And if it's something that requires them to do something, they can get started on it. Even if it's something as common as a DUI, one of the typical things that's required of a defendant who pleads in a DUI case is they have to go to class. You know, they need to go for a certain amount of time, they need to do a certain amount of community service, and if a lawyer can get that case resolved, that person is going to go to class sooner. They're going to start their rehabilitation sooner. They're going to do their community service sooner. They're going to get through what they need in order to reintegrate back into society the way that they should. Not driving drunk. That's dangerous for everybody, right? So the revolving door, when it comes to bail, it's a tough one, but a lot of times the judge's hands are tied. And the revolving door about repeat offenders, even after they've pled, unfortunately, if that happens, then the next time when you go through it, you just have to look at it with, a much sharper eye because you don't want to have it happen again and again if you can help it. So that's what you got to do. That's what I would do. You just got to be very careful when these cases come in to look at all of the factors, all of the facts, what its effects are on everyone, and try to put together something that's going to make sure people come to court, that cases get resolved, and that once the sentence is done, that people carry out their sentences, whether they're in custody or whether they have to pay their restitution and do their community service and rehabilitate or whatever it may be.
I have a question about realignment, and forgive me if this maybe is, again, maybe not the best thought out question in the world, but I think that the school of thought I've seen in our local courts since realignment, so it's been at least 2 years now, maybe 2 years, is that it's really changed the way judges are sentencing because of the possibility of the post-release community supervision versus sending somebody to prison
Right.
and then not
Right.
being able to supervise them once they're done with their term. And I don't know if you have a perspective on how well that's working. or what kind of special challenges that poses?
Well, you're right. And statistically, I don't know. And I don't know how easy it would be to find statistics. I can tell you that the probation department plays a huge role. And if the probation department is adequately funded and properly staffed, and they're doing a good job, which I think they are going to go a long way towards rehabilitating people that, if they're sitting in state prison, may not get any rehabilitation at all. Again, it's one of those things where you have to look at each case individually, and I apologize for saying that again, but I don't know how any particular case may turn out, and I don't have the statistics, after the realignment. I apologize, I can look that up, but you're right. There's always that balance, and the judge has got to look at it. And if they have discretion, they have to make the best call based upon what they think is fair. They need to be fair. That is, fair and impartial are two prongs of being a judge that are inescapable. You absolutely have to be those things no matter what, and that's what every judge is trying to do. So. I don't know, you may not like that answer very much, but I think the reality is we just have to keep working. We have to keep studying. We have to pay attention to every case very carefully and very closely, and try to make the right decision.
For you, and for me, I'm not really sure how much time you've spent in Nevada County courts, but given what experience you've had there, I'm wondering what kind of specific challenges you see for somebody who's going to be taking a judicial seat here in this county. Yeah,
I've spent a lot of time in court in Nevada County. I've never been in family court. I've never been a family law practitioner, so I've never spent time in family court anywhere. I haven't spent any time in tax court either, because I'm not a tax attorney, but I spent a lot of time in civil court, and I've spent a fair amount of time in criminal court, and here too. Like I said, I think that I have more experience in Nevada County courts than all of my opponents except for Anna. Because I know we're both in court a lot, and she's in court only here all the time, and I'm in court other places too. But I've been in the Nevada County Courthouse many, many times, and I would say when we're looking at challenges from the judicial point of view, that Nevada County is blessed with a lot of great things with our courthouse. Not the actual courthouse itself, and that's another issue.
Which is another question for you.
Okay, and it'll be fantastic to have a new courthouse, and it's inevitable that there either will be a new courthouse, or maybe there's a teeny tiny chance that they're able to retrofit the existing courthouse. But from everything I've read, that doesn't sound feasible at all. So it's probably just a matter of time until we have a new courthouse, which would be great. But you got to make do with what you got. So I remember early in my career, the courts were so impacted they couldn't build courthouses fast enough that they would literally put trailers, like FEMA trailers, and you would have the judge sitting in a trailer and people in folding chairs, and we would have to go to trailer court because there was nowhere else to go, and we had to get our cases. We had to work through our cases. So from that point of view, this courthouse, of course, it could be better, but it's still functioning better than other places that I've been to. So the challenge is to keep the cases moving. And here, luckily, the docket, or the calendar, is pretty light, particularly compared to larger counties. If you go to the Bay Area, Los Angeles, San Diego, Orange counties, you may not get a hearing date on a motion for 3, 4, 6 months or more. You just can't even get into court. And the calendar is so tight and so impacted that judges will often put a time limit on how long you can argue. So imagine a motion that took a lawyer 100 hours to write, and it's a very important issue, and it could decide a case. And you then have to wait 6 months, and then the judge gives you 5 minutes to argue. That is really a problem, because it's hard to be prepared, and it's hard to make the right ruling if you don't have the information. Information without perspective is not nearly as valuable. So one of the challenges here is to make sure that the calendar keeps moving. And luckily, right now, Nevada County courts are great because there is plenty of time for for everyone to get in. And you've been there. We've had hearings in front of Judge Dowling where we've argued for 2 hours or more. I mean, we could take a half a day on an important issue here that other places you would get 5 minutes. So one of the challenges is to make sure that that continues. So I'm very cognizant of that. One of the other issues I know that people talk about at this courthouse is, and it's strange, but it's actually a good thing, that people that are in custody are very close to the other people in the courthouse. And that's one of the criticisms of the new courthouse, is that people that are in custody are too close to the citizens because there's a potential for danger. You may know better than I, but I don't recall any instances in the last, I would say, 3 years that I've been in the Nevada courthouse frequently, where an inmate has ever tried to attack somebody because they were in too close a proximity to them.
Right.
In other places where there's dangerous people that are trying to attack people, that is a huge concern. And I know it's a concern here too, but luckily we haven't had any incidents, and hopefully we never will. But that's certainly something that we have to keep an eye on. And the sheriff's deputies that are at the courthouse are all great. I mean, I see them, the bailiffs and the sheriffs that are there, and they're ready. They're protecting people. So as long as they're vigilant and keeping an eye on that, I think that's a potential problem that we can avoid. The other thing that I have seen everywhere, and I do not want to become a problem here, is making sure that the lawyers are prepared. It is one of my pet peeves to go to court and either the judge isn't prepared because he didn't have time, didn't read the pleadings, or that the other lawyer isn't prepared, and as a result they ask for a continuance, or we need to get more information, or the discovery that's been asked for hasn't been prepared, and you get that that very, very precious time in front of the judge, and it's wasted because the lawyers aren't prepared. And that's something that I will not stand for. If a lawyer comes into court and says, I can't argue this motion today because I was waiting for discovery from the other side, and the other side has had plenty of time to do the discovery, for example, and they haven't, and now we've just wasted everybody's time. That is a problem, and we need to make sure that doesn't happen too. So, being prepared is going to be one of the biggest challenges, to make sure that everybody keeps things moving, and that's one of the things that I'm going to be very, very, very tough on.
So about the courthouse.
Okay.
So, I mean, from your perspective, the current building is just not, you don't think it's would ever be
From what I've read, and I've read the studies, it sounds like it's just not feasible to retrofit this courthouse and make it safe and make it function the way that it should. Also, there's problems with parking, for example. Although I must say that I've been other places where you have to pay $24 to park and then walk 4 blocks to get to the courthouse. And here you can park for a quarter for an hour. So although it's hard for the jurors sometimes when they come in and park at this courthouse, and it would be nice to have a big expansive parking lot and a beautiful new building, we still have tools to work with here, and we can still make sure that people get their day in court, and if they have to walk a little longer, we'll try to accommodate them, but it's not the end of the world. Like I said, if we can try cases in trailers, we can try cases here.
This is totally beside the point, but have you ever been in that tiny little courtroom in Lincoln?
Oh, no, not in Lincoln, but like Tahoe City has a trailer. Tahoe City has a trailer, and it is teeny. It's about the size of this room. So, yeah.
Yeah, I don't even know if they still use it, but it was behind what was like the turn of the century jail. I mean, it's literally...
Yeah. It's
Most
crazy.
bizarre little room.
It is, but on the other hand, I don't know if you've ever been to the courthouse in Santa Barbara. Santa Barbara's courthouse, I think, was built in Spanish style, I'm guessing in the 1880s. So it's adobe looking and, red tile roof. And then the courtrooms are these huge, ornate, wood everywhere, giant, absolutely gorgeous courtrooms that people have been trying cases in for 100, 150 years maybe, I don't know. And you walk in there and you feel like you're going back in time. It's just awesome. So, the Santa Barbara courthouse in fact, the Santa Barbara courthouse is so cool that they have weddings there. I mean, and not weddings like you go to the Justice of the Peace, like on the lawn, outside. It's really cool. But also, there's new courthouses being built all over the place. And some of the new courtrooms are fantastic. I'll tell you an example in San Diego. I tried a case once for 14 weeks, and it killed me because they built it was a new courthouse, and there was a window that overlooked the San Diego Bay. And when they built the courtroom, instead of putting the jurors with their back to the window and facing everybody, they put the jury box on this side so the jurors could look out the window and watch the sailboats go by all day long.
Wow.
And so we had this long trial, and those jurors were there forever. And in the afternoons, you could just see them all just looking out the window at the water, wondering when they got to go home. So, be careful what you wish for, right? Because we build a big, beautiful courthouse and has all these amenities and all the electronics.
That I didn't ask you.
Oh, right. The question that all of us are asked all the time, and it's a good question, is why would you want to be a judge in Nevada County? And the answer is, we all want to be judges for the same reason, and that's because we've all had long careers as lawyers, and being a judge is so important to the judicial system, and it's such an honor to play such an important part because you're involved in every case that's in your courtroom, right? You get to know the litigants, you get to know the lawyers, you get to know the people. You're really hands-on involved, which makes it a great job. Also, it's a great academic job because me, for example, and I think you know this, is that I've done a ton of writing and I do a ton of reading. So if you don't like reading and you don't like writing, you shouldn't be a judge. And if you're not patient and if you're not detail-oriented, you shouldn't be a judge. Those are all things that I really enjoy, so that's why I think it's a good fit being a judge. Being a judge in Nevada County is spectacular because not only is this a wonderful place to be, I mean, God's country, we know that. It's awesome here. The people are great, the weather's great, the lifestyle is great, but from a judicial point of view, the reason that I want to be a judge in Nevada County is unlike these other counties we were talking about earlier. Let's pick Los Angeles, for example. Mm-hmm. The judges there have a very different role in the judicial system because they're just trying to keep up. They don't get to do what they really want to do, and that is to be actively involved in their cases, to be able to take the time to be with the lawyers, to hear different types of cases. For example, in these larger counties, the presiding judge is going to pigeonhole everybody into one type of case. It happens all the time. For example, for the first half of my career, I did a lot of work representing builders, contractors, and any construction defect case would always go to the same judge. That's it. That's all he got to hear. Just construction cases every day, all day long, forever. Here, presiding judge, you may hear, primarily criminal cases. You might hear primarily civil cases, but you're going to get to hear all different kinds of cases every day. When you get to go to court, put your robe on and sit down and look at the docket, you're going to see all kinds of things. You're not just going to see the same thing over and over. So that makes it really appealing to be a judge here, because being a judge in a smaller, more rural county means that you're going to hear a lot different types of cases, a lot different types of disputes. You're going to hear, cases up here about things that you're not going to hear in downtown LA. The cases that are being heard there, those issues don't even exist here. So
you don't get a lot of bear poaching cases?
Right, no, exactly. You don't have, I don't think there's been a mineral rights case in LA since probably 100 years ago, I don't know. So here, being a judge in a smaller judicial community is great because you get to be a lot more hands-on. You get to take more time. You get to have a much broader diversity in the kind of cases you get to hear and the kind of work you get to do. So that's why I want to be a judge here.
I don't know if this has been an issue, but you know, you're pretty much coming from out of county. I mean, you've moved here.
Yeah,
I mean,
up
I would
here?
assume primarily to be able to run.
No, exactly the opposite.
Okay.
I came here. I've been coming here frequently for 5 years. We started. ASA hired me in 2011. Right, that's when we started working with the board of supervisors.
God, was it that long ago?
Yeah, because I think the lawsuit was filed in. This is the third season.
Right.
So we started way back then.
Okay.
So no, I came here because I had friends here. I came here because I had work here, and it was interesting work, and I liked it here, and I stayed. I didn't know that Judge Dowling was going to retire when I opened my office here. You know, I didn't know that I was going to have an opportunity to run for a judge here when I opened my office here and took all my cases and got to meet the local bar and, you know, and the people here and you know, all the things that I've been doing. So no, it's the exact opposite. The reason I'm running for judge here now is because now is the time that Nevada County needs a judge. I came here because I like it here and because I liked working here. So no, I'm very comfortable here. I mean, I know lots of people. I have tons of friends. I know my way around, you know, perfectly. In fact, I'll tell you a story. Yesterday, I spent the entire day panning for gold with a friend of mine who is a woman in her mid-60s. She's great, and I've been meaning to go panning for gold, and she works at State Park, and she teaches gold panning. So she said, "Oh, we can do it. That's fine. Let's go." So I went and I picked her up, and we went to I think it was Oregon Creek where it hits the middle fork of the Yuba River.
Yeah.
And it was beautiful yesterday. I mean, we walked over a covered bridge, you know, one of the old wooden covered bridges. The creek was maybe 30 yards wide, and it was, you know, down a little bit after the rain last week. The sun came out, and we put our boots on, and we panned for gold all afternoon. And it was so relaxing and so fun. It was great. I really had a good time. So, you know, that's the kind of thing you can do here. And those are the kind of people you can do it with. It was fantastic. So, yeah, no, I'm very happy here.
Is there anything I haven't asked that you kind of want to get across to people, our readers?
You know, I would say, you know, you're right that in a typical judicial race, nobody knows, you know, and a lot of people don't even vote for a judge because they don't know anything about the judges. So what I would do is I would encourage people to try to meet us. We're here, we're around, you know, all the time. And go to events if you want to. You know, there's lots of places to get to know us. You can call me if you have a question. You can write me an email. You can visit the website. You know, you can learn about us. But also, I really would like people, before they vote, first of all, they need to vote. Everybody needs to come out and vote, no matter who they vote for. It's very, very important. You know, I was an international relations major in college, which is political science, and so I studied political science for a long time. And without the voters coming out, then all the work that we're doing now to try to educate everybody and let them get to know us is wasted. So I would first of all implore that everyone come out and vote. But the second thing I would do is I would ask everybody to really try to understand the personality of who they're voting for. We're all very well qualified. And like we talked about earlier, we all come from different backgrounds, and we all have different perspectives as to how we see the law and what we think is important in the law. But I think the voters, what I would tell them all is if you get to know me and you understand that I am very fair, you know, I've always tried very hard, even as a lawyer, to be very professional with the other lawyers and the judges and my clients and the opposing, you know, the people on the other side. And if you ask people that know me, I'm very confident that they will all say, yeah, no, that's right. Jeff is actually he's a good lawyer. He's a good guy. He's easy to work with. And the question at the end of the day is going to be, who do you want to work with when you come into court? You know, if you are in law enforcement, if you are a bailiff, if you are a clerk, if you are a lawyer, if you are a party, if you are a defendant, if you're an expert, no matter who you are, at the end of the day, you have to be working with the judge. right? So who do you want to work with most? Who's going to treat you the best? Who's going to be fair? Who is going to be prepared? Who is going to have a good decorum? Who is somebody that you can talk to? Who is somebody that will listen? Who is somebody that's going to help your case resolve? And, you know, I think that if people get to know me, they're going to understand that I'm easy to work with and that people are going to get the results they want, and that's why they'll vote for me.
Okay. I just realized